30,000 square feet. That's what the document said. An apartment 3 times the size of most American homes, valued at $327 million. Except it wasn't 30,000 square feet. It was 10,996. Simple math, right? Measure the space, report the number. But for nearly 2 decades, that lie, and dozens like it, was used to secure billions in loans, to dazzle banks, to prove wealth that existed only on paper, until February 2019, when a man who'd spent 10 years protecting these secrets walked into a congressional hearing room and decided to tell the truth. This is the story of how the numbers didn't add up, and what happened when someone finally checked the math. February 16th, 2024, 9 a.m., Manhattan. A courtroom at 60 Center Street falls silent as Judge Arthur Engeron prepares to read his decision. The case has consumed 3 months of testimony, 44 trial days, and generated headlines across the world. The defendant, Donald J. Trump, real estate mogul, former president of the United States, current candidate for the 2024 election. The charge, persistent and egregious fraud. When the judge finishes reading, the numbers are staggering. $354.9 million in penalties. With interest, the total approaches $464 million. A 3-year ban from running any company in New York. His sons, Donald Jr. and Eric, barred for 2 years. The Trump legal team promises immediate appeal. Trump himself calls it a witch hunt, political persecution, election interference. But the judge's words are unambiguous. 92 pages of findings. And on page 1, 3 words that would define the entire case. Intentional, egregious, persistent. This wasn't a mistake. This wasn't aggressive accounting. This was fraud. To understand how we arrived at this moment, we need to go back to when the illusion began. 1971. Donald Trump is 25 years old when his father, Fred Trump, hands him control of the family real estate business. Fred had built an empire in Brooklyn and Queens, middle-class apartments, steady income, nothing flashy. But Donald had a different vision. Brooklyn was yesterday. Manhattan was tomorrow. He wanted his name on towers, not tenements. The 1980s became his proving ground. Trump Tower opened in 1983, 58 stories of black glass and brass, 5th Avenue and 56th Street. His apartment occupied the top floors. The lobby? Pink marble, 80-foot atrium, a waterfall. Excess is architecture. He bought the Plaza Hotel, built casinos in Atlantic City, splashed his name across everything in gold letters 4 feet tall. The persona calcified, gold-plated, larger than life, perpetually winning. He wrote a book about it, The Art of the Deal. Then came the 1990s and the art nearly collapsed. Casino bankruptcies, $900 million in personal debt. Banks circled, the empire teetered. But Trump discovered something crucial. The brand was worth more than the buildings. He couldn't always make money from real estate, but he could always make money from his name. Licensing deals, his name on buildings he didn't own, on steaks, vodka, neckties. The product wasn't apartments anymore. The product was Trump. 2004 brought The Apprentice. 14 seasons of You're Fired beamed into American living rooms. The show resurrected him as a cultural icon, not just a developer, a symbol of success itself. The empire expanded again. Golf courses in Scotland, Ireland, Dubai, Mar-a-Lago, the Palm Beach estate he'd bought in 1985 for $5 million, transformed from private home to exclusive club to political fortress. By 2011, the Trump Organization touched 3 continents. Hotels, golf courses, residential towers, and everywhere the same philosophy. It's not what it's worth, it's what you can convince people it's worth. But there was a problem with that philosophy. Banks don't accept perception. They require documentation, they need numbers, financial statements, proof, and that's where things get interesting. Between 2011 and 2021, Donald Trump submitted annual financial documents to banks and insurance companies. They were called Statements of Financial Condition, SFCs in industry jargon. These weren't tax returns. These were declarations of net worth. Everything he owned, everything he owed, calculated to the dollar. The purpose was simple. Prove you're wealthy enough to borrow more money, or wealthy enough to insure your properties at favorable rates. The banks reading these statements were major institutions. Deutsche Bank alone loaned Trump over $2 billion across multiple properties. Capital One, Ladder Capital. They weren't small-time operators. The insurance companies were equally sophisticated. Zurich, Allianz, dozens of others covering everything from property damage to liability claims. These institutions required financial statements before approving loans or policies. Standard practice, due diligence. Trump's statements showed consistent, impressive wealth. $4 billion, $5 billion, $6 billion. The numbers climbed year after year. The man preparing these statements was Alan Weisselberg, chief financial officer since 1986, 40 years with the organization. He knew every property, every mortgage, every number in the empire. If anyone understood the real financial picture, it was Weisselberg. The process worked like this. Weisselberg's team would compile valuations for every major asset. Trump would review them. Often, he'd adjust the numbers upward. Then Trump would sign the statements personally. His signature, his representation, his responsibility. The statements went to banks, to insurers, to anyone who needed proof of wealth. And on every statement, there was a disclaimer, a paragraph in small print from the accounting firm. We have not audited, reviewed, or compiled these financial statements. Users should undertake their own due diligence. Standard language, a legal buffer. It meant we're reporting what the client told us, not verifying it. But here's the catch. That disclaimer doesn't protect you if you knowingly lie. The statements claimed Trump's net worth ranged from $4 to $6 billion throughout the decade. The properties looked pristine on paper. The numbers consistently impressive, suspiciously impressive. And in February 2019, someone who'd spent a decade inside that system decided the numbers deserved scrutiny. The man who would eventually call these methods fraudulent was, at that moment, still protecting them, Michael Cohen, personal attorney to Donald Trump, the fixer, the dealmaker, the man who made problems disappear. He'd helped prepare financial statements. He'd negotiated with banks. He knew how the valuations were created. He knew which numbers were flexible. But in early 2019, Cohen was no longer working for Trump. He was preparing to testify against him. February 27th, 2019. A congressional hearing room in Washington, D.C., cameras everywhere. Michael Cohen sits at a table facing the House Committee on Oversight and Reform. He's already a convicted felon. Campaign finance violations, tax evasion, lying to Congress, sentenced to 3 years in federal prison. His credibility is shattered, his loyalty to Trump severed. But he brings something valuable, documents, and detailed knowledge of how the Trump organization operated behind closed doors. His testimony is methodical, specific, damning. Mr. Trump inflated his total assets when it served his purposes, Cohen tells the committee. He deflated his assets to reduce his real estate taxes. He describes how Trump would call Forbes magazine anonymously, using the fake name John Barron to inflate estimates of his wealth, how financial statements exaggerated property values to secure loans, how insurance companies were deceived about what properties were actually worth. Then Cohen mentions the apartment, the triplex at the top of Trump Tower. Mr. Trump's apartment, Cohen says, he said it was 30,000 square feet. It was 10,000, and the number lands like a bomb. Not a subtle overstatement, not creative accounting, a lie so blatant it seemed almost careless. Cohen provides documents to the committee, bank records, financial statements, some with Trump's signature clearly visible. Republicans on the committee attack Cohen's credibility, convicted liar, seeking leniency from prosecutors, bitter over his legal troubles. Democrats argue the opposite. Cohen knows the system because he operated it. His crimes make him credible. He has nothing left to protect. And in Albany, New York, Attorney General Letitia James is watching, taking notes. Cohen had learned from the master. He knew the art of the deal. He also knew the art of inflation. Within weeks, James' office opens a civil investigation. Not criminal, civil. That distinction will matter later. The legal tool is New York Executive Law, Section 63, subsection 12. It allows the Attorney General to investigate persistent fraud or illegality in business dealings. It doesn't require proving someone was harmed. Just that fraud occurred, a pattern of deception. The advantage of civil over criminal, lower burden of proof. In a criminal case, prosecutors must prove guilt beyond a reasonable doubt, the highest standard in law. In a civil case, the standard is preponderance of evidence, more likely than not, 51%. Letitia James had campaigned on investigating Trump. Her critics would later call this political motivation. Her office maintained it was simply following evidence from Cohen's testimony. The investigation begins quietly. Subpoenas for documents, requests for financial records. The Trump organization fights every step, appeals, delays, legal motions arguing the investigation is politically motivated, an abuse of power, a violation of Trump's rights. Eventually, the courts force compliance. Thousands of pages of documents flow into the Attorney General's office. Financial statements, property appraisals, loan applications, email chains discussing valuations. August 2020. Eric Trump is deposed. He sits for questioning under oath. Over 500 times he invokes his Fifth Amendment right against self-incrimination. On advice of counsel, I decline to answer. 500 times. The spectacle is notable. The Fifth Amendment protects against self-incrimination. It's a constitutional right, but in the court of public opinion, the question lingers. If nothing is wrong, why not answer? January 2022. Donald Trump himself is deposed. 4 hours of questioning. 440 times he invokes the Fifth Amendment. Same answer. Later, at a rally, Trump would say, "The mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?" But in that deposition room, he took it 440 times. By mid-2022, investigators have found the pattern. Not isolated errors, Not aggressive, but defensible valuations. Systematic inflation across multiple properties, spanning over a decade. The same methodology, repeated annually. September 21st, 2022, the lawsuit drops. 222 pages, filed in New York Supreme Court, Manhattan. The civil complaint names Donald Trump Jr., Eric Trump, Ivanka Trump, Alan Weiselberg, Jeffrey McConney, the organization's controller, and 10 Trump organization entities. The allegations: grossly and fraudulently inflated asset values to deceive banks and insurers. Over $3.6 billion in fraudulent net worth claims. 23 assets under scrutiny. But 5 examples stand out. 5 properties where the inflation was so extreme, so documented, so provable, they became the prosecution's smoking guns. First, Mar-a-Lago. Trump bought the Palm Beach estate in 1985 for $5 million. A historic property, sprawling and elegant. He lived there. Then, in 1995, he converted it to a private club. To do this, he signed a deed restriction with the town of Palm Beach. The restriction was permanent. The property could never again be used as a private single-family residence, only as a club. That restriction limited the property's value significantly. But Trump's financial statements valued Mar-a-Lago at $739 million. They treated it as if it could be sold as an unrestricted private residence. Comparable estates in Palm Beach without restrictions might sell for $75 million, maybe $100 million maximum. The gap. Nearly $700 million of overvaluation. Second, the Trump Tower triplex. Michael Cohen had mentioned this in his testimony. The details were even more stark in the lawsuit. Financial statements listed the apartment at 30,000 square feet. The actual size, confirmed by building records and architectural plans, 10,996 square feet. Trump valued the apartment using price per square foot calculations based on the inflated size at $6,000 per square foot. A premium Manhattan rate, 30,000 square feet, meant $180 million. The actual size at the same rate would be about $66 million. The financial statements valued it at $327 million, based on a square footage that was demonstrably, mathematically, provably false. And evidence showed Trump knew the real dimensions. A Forbes magazine article from 2017 had quoted him discussing the apartment's actual size, 11,000 square feet. Third, 40 Wall Street, a 72-story office tower in Lower Manhattan. Trump acquired it in 1995, and it became a crown jewel of his portfolio. In 2010, Trump commissioned a professional appraisal, standard practice before refinancing. The appraisal came back $220 million. Trump's financial statements in 2011 and 2012 valued the building at $524 to $530 million, more than double the professional appraisal. He used the inflated value to secure loans from Capital One and Ladder Capital. Hundreds of millions in financing, backed by a valuation that contradicted his own appraisal. Fourth, Seven Springs Estate, 212 acres in Westchester County, New York. A sprawling property Trump purchased in 1995, envisioning a golf course or luxury home development. The plans never materialized. Instead, Trump donated a conservation easement to a land trust. The donation generated a $21.1 million tax deduction. The easement permanently restricted development on most of the property. But Trump's financial statements valued Seven Springs at $261 to $291 million. They used development potential, the ability to build luxury homes, to justify the value. The problem? He'd already surrendered the development rights through the conservation easement. You can't count the value of development rights you've donated away. And you can't claim a tax deduction for donating those rights while also telling banks those rights still inflate your net worth. Professional appraisals valued the property post-easement at about $30 million as an assemblage of a few buildable lots. Fifth, Aberdeen Golf Course, Trump International Golf Links, Scotland, opened in 2012. Trump called it the greatest golf course in the world. His financial statements valued it at $327 million. The evidence told a different story. The course lost money every single year since opening. It never recorded a profit. Annual losses ran into the millions. The valuation method used brand premium and anticipated future value. But banks don't loan money based on hopes and brand cachet. They need current market value. What would someone pay for this asset today? Nobody pays $327 million for a business that loses money every year. The pattern across all 5 examples and 18 others in the lawsuit was identical. Every valuation favored Trump. Every error inflated, never deflated. Every mistake ran in the same direction, up. The defense strategy was already clear from pretrial motions. Sophisticated banks do their own analysis. They weren't fooled. They made money on the loans. No victims, no fraud. But the Attorney General's office had a different theory. The fraud wasn't about fooling expert bankers. It was about market advantage, about getting loan terms honest competitors couldn't access, about saving money on insurance premiums, about building a reputation on false claims of wealth. The case was heading to trial, and before it even started, Trump would suffer a devastating legal blow. September 26, 2023. 3 days before trial begins, Judge Arthur Engoron issues a ruling that changes everything. Summary judgment on the primary fraud claim, liability established as a matter of law. In plain language, the judge rules that fraud occurred, not allegedly occurred, not might have occurred, occurred. Before hearing a single witness, before the trial even opens, the core question is decided. The judge's reasoning is stark. Quote, "The frauds leap off the page and shock the conscience. The evidence, the financial statements, the property records, the comparative valuations, is so overwhelming that no trial is needed to establish the basic fact of fraud. The numbers speak for themselves. The penalty at this stage, cancellation of business certificates. The Trump Organization's authority to operate in New York is revoked. The judge considers appointing a receiver to take over the company, but ultimately settles on an independent monitor, a court-appointed overseer who must approve major business decisions. What remains for trial? The amount of damages, individual liability for Trump's sons and executives, and additional claims beyond the core fraud finding. Trump's reaction is immediate and furious. Corrupt judge, rigged system. Election interference timed to damage his 2024 campaign. Legal experts call it a devastating pretrial loss. The defense's entire strategy, no fraud occurred, is eliminated before opening statements. But the judge had ruled. The fraud was proven. Trump wasn't backing down, and the courtroom drama that followed would become a spectacle unlike any in American legal history. October 2nd, 2023. The trial opens at 60 Center Street in Lower Manhattan. A critical detail, this is a bench trial. No jury. Judge Engoron alone will decide the case. No jury to sway with emotion, no jury instructions to parse. Pure legal analysis of facts and evidence. The courtroom fills daily. Overflow crowds spill into hallways. Reporters from around the world. The atmosphere electric with anticipation. The key players. Judge Arthur Engoron, a veteran of the New York Supreme Court since 2003, known for sharp questions and little tolerance for theatrics. Attorney General Letitia James, present for major testimony days. Her senior prosecutors, Kevin Wallace and Andrew Amer, handle the day-to-day questioning. Trump's defense team, Alina Habba, Christopher Kaise, and Clifford Robert. They face an uphill battle. The fraud is already established. They need to minimize damages and protect the Trump sons from individual liability. Trump's strategy: attend trial on key days, speak to the media outside the courtroom, call it a witch hunt, attack the judge on Truth Social, create a parallel narrative for public consumption separate from the legal proceedings inside. The strategy backfires when Trump's social media attacks target the judge's law clerk. Judge Engoron issues a gag order. Trump violates it. The gag order expands. Eventually fines are levied, $10,000. The courtroom drama spills beyond the legal questions into questions of decorum and respect for the court itself. The witnesses begin. October 10th and 11th, Alan Weisselberg takes the stand, 76 years old, chief financial officer of the Trump Organization for 49 years. He'd started in 1973 working for Fred Trump. He'd risen with Donald. He knew every deal, every property, every financial maneuver. But Weisselberg is already a convicted felon. In August 2023, just 2 months before this trial, he'd been sentenced to 5 months in jail for tax fraud, a scheme involving unreported compensation, company cars, and apartments provided by the Trump Organization. He's testifying under immunity for this case. His answers can't be used to prosecute him further. The prosecution walks him through the financial statements, page by page, valuation by valuation. The Trump Tower triplex square footage. I was wrong, Weisselberg admits. He discovered the error in 2017 when a Forbes article mentioned the correct size, but the financial statements were never corrected. Years of filings continued with the false number. The Mar-a-Lago valuation. He can't explain the methodology. It was a determination by Mr. Trump, he says. Cross-examination by the defense tries to establish that Weisselberg was following standard real estate practices, that valuations are subjective, that banks do their own analysis anyway. But the admissions stand. The numbers were wrong. The errors favored Trump, and when discovered, they weren't fixed. November 1st, Donald Trump Jr. testifies, executive vice president of the Trump Organization, trustee of his father's assets during the presidency. He signed financial statements from 2017 to 2020. His defense is consistent. I'm a real estate developer, not an accountant. He testifies he relied on the accounting team, on Weisselberg, on the controllers, on the lawyers. He signed what they prepared. The prosecutor's questions are direct. You signed this statement? Yes. Did you verify these numbers? I assume the team did that. Did you personally check the valuations? No. The problem? Signing your name to a financial document creates legal responsibility. Whether you verified the numbers or not, your signature means you're representing them as accurate. November 2nd, Eric Trump takes the stand. Executive Vice President running day-to-day operations of the organization. His testimony attempts deflection. He wasn't involved in preparing financial statements. That was the CFO's domain, the accounting team's responsibility. But prosecutors produce emails. Eric's emails discussing property valuations, specifically the Aberdeen Golf Course in Scotland. Messages where he provides input on projected revenues, on the value of the brand, on numbers that ended up in financial statements. The contradiction is obvious. The defense adjusts. He provided operational input, but not financial statement preparation. The line is thin. The exchanges with prosecutors grow testy. Eric defends his father. He's the most honest person I know. The courtroom murmurs. The judge calls for order. November 6th. The main event. Donald Trump takes the stand. The former president of the United States testifying in a civil fraud trial. Unprecedented. Extraordinary. The courtroom is packed beyond capacity. From the first question, the tone is combative. Trump doesn't simply answer questions. He makes speeches. He attacks the attorney general, the judge, the entire proceeding. Judge Engoron repeatedly, "Mr. Trump, just answer the question." Trump's defense strategy appears to be creating sound bites for media coverage rather than persuading the judge. He calls the case a political witch hunt. He insists the valuations were conservative, not inflated. On Mar-a-Lago, it's worth $1 billion, maybe more, much more. Judge, that's not the question I asked, Mr. Trump. On the triplex, he blames accountants. He blames Forbes magazine for publishing the wrong number initially. He says the actual size doesn't matter because buyers care about the apartment's prestige, not square footage. On bank relationships, the banks loved us. We made them a lot of money. They were very happy. The problem with this defense, the judge has already ruled fraud occurred. Trump's testimony does little to address damages or individual liability. Instead, it reinforces the portrait of someone who believes the rules don't apply to him. The courtroom is cleared multiple times during heated exchanges. Trump's lawyers look visibly uncomfortable. At one point, Judge Engoron threatens to cut the testimony short if Trump can't follow basic courtroom protocol. This wasn't the art of the deal. This was the art of denial. The expert witnesses follow. The prosecution brings Michelle McCarty, an accounting expert, who walks through the financial statements line by line. He shows the systematic pattern, the consistent inflation, the methodology that violates generally accepted accounting principles. Real estate appraisers testify that Trump's valuations aren't credible. They don't reflect market conditions, comparable sales, or standard appraisal methodology. The defense counters with their own experts. Eli Bartov, an accounting professor from New York University, argues that sophisticated banks do independent analysis. They weren't deceived. They didn't rely solely on Trump's statements. Defense real estate experts testify that valuation is a subjective art, not an exact science, that different methodologies can produce different numbers, that Trump's aggressive valuations, while high, aren't necessarily fraudulent. November 16th, closing arguments. The Attorney General's team, this is a clear pattern of fraud designed to enrich himself at the expense of market integrity. The defense, no victims, no harm, no fraud. Banks made money, insurance companies paid no claims. Mr. Trump built a successful business and harmed no one. Judge Engoron takes the case under advisement. 3 months of waiting. February 16th, 2024, 9 a.m. Eastern Time. The ruling is posted online. 92 pages, single-spaced, dense legal reasoning backed by hundreds of citations to evidence and testimony. Page 1 includes 3 words that define everything: intentional, egregious, persistent. Judge Engoron's findings are unambiguous. Donald Trump, his sons, and Trump Organization executives intentionally committed fraud. The financial statements were blatantly false. These weren't innocent mistakes or aggressive accounting. This was systematic deception that continued even after errors were identified. One line would be quoted in every news report. Their complete lack of contrition and remorse borders on pathological. The penalties are severe. Donald Trump, $354.9 million in disgorgement. That's the legal term for ill-gotten gains. Money obtained through fraud that must be returned. Prejudgment interest adds roughly $100 million more. Total, approximately $464 million. Beyond the money, a 3-year ban. Trump cannot serve as an officer or director of any New York corporation. He cannot apply for loans from any New York chartered bank during the ban. Donald Trump Jr. and Eric Trump, $4 million each. 2-year bans from serving as corporate officers in New York. Alan Weisselberg, $1 million. A 3-year ban. The Trump Organization itself, an independent monitor, Barbara Jones, a former federal judge, continues oversight for at least 3 years. An independent compliance director must be installed. Regular financial reporting to the court. outside oversight of every major business decision. The structure of accountability is comprehensive. This isn't just a fine, it's a restructuring of how the Trump organization operates. The legal reasoning demolishes the no victims defense. Judge Engeron writes, "The frauds found here leap off the page and shock the conscience." He continues, "Defendants' refrain that the world of high finance is complex doesn't explain how defendants falsely inflated everything. On the claim that sophisticated banks weren't fooled, not all victims are immediately apparent. Market integrity is harmed. Honest businesses are disadvantaged when competitors cheat. The financial system requires honest dealing. The ruling emphasizes that fraud doesn't require proving someone was harmed. The statute prohibits persistent illegality in business dealings. Pattern of deception is sufficient. Specific findings on the 5 major properties. Mar-a-Lago. The valuation was absurd and fraudulent. The deed restriction eliminates any possibility of residential sale. $739 million for a property worth perhaps $75 million is fraud, not aggressive valuation. Trump Tower triplex. A discrepancy of this order of magnitude by a real estate developer sizing up his own living space of decades can only be considered fraud. The judge notes Trump knew the correct size from the Forbes article, yet continued using the false number. 40 Wall Street. Ignoring a professional appraisal you commissioned, then inflating the value to double that appraisal for loan applications, is fraud. 7 Springs. Defendants cannot have their cake and eat it too, claiming a tax deduction for donating development rights while simultaneously valuing the property as if those rights still exist. Aberdeen. Valuing a money-losing business at $300 million based on brand premium is not a valuation. It's wishful thinking disguised as accounting. The ruling addresses Trump's testimony specifically. Donald Trump rarely responded to the questions asked, and he frequently interjected long, irrelevant speeches. On the lack of remorse, the defense argued this was a venial sin, not a mortal sin, a minor transgression. Judge Engeron. Defendant's complete lack of contrition is sanction-worthy in itself. The legal framework underlying the decision deserves understanding. This is a civil case, not criminal. Why does that matter? Manhattan District Attorneys Cyrus Vance Jr. and later Alvin Bragg investigated Trump criminally. They reviewed the same evidence. They ultimately decided the evidence supported a civil case more strongly than criminal prosecution. Civil cases use a lower standard of proof. In criminal court, prosecutors must prove guilt beyond a reasonable doubt, the highest standard in American law, roughly 99% certainty. In civil court, the standard is preponderance of evidence, more likely than not, 51%. Did the fraud more likely occur than not occur? The evidence met that standard overwhelmingly. Civil penalties can be severe without including jail time. Hundreds of millions in fines, bans from operating businesses, court-ordered oversight. These consequences reshape Trump's business empire without criminal conviction. The no victims defense, the cornerstone of Trump's argument, was systematically rejected. The defense claimed banks made money on the loans. Insurance companies paid no claims. Nobody lost anything. Where's the victim? Judge Engeron's response draws on legal precedent. New York law doesn't require victim testimony to prove fraud. The statute targets persistent illegality that undermines market integrity. When someone obtains loans through false financial statements, they gain unfair advantage over honest competitors. They distort the market. They erode trust in financial systems. Other developers who reported accurate valuations lost loan opportunities. Capital that went to Trump based on inflated values was capital denied to legitimate businesses. The judge cites People v. Coventry. First, a 2013 New York case establishing that fraud can be proven without specific victim testimony. Pattern of deception is sufficient. Personal liability attached because Trump signed the statements, his signature, his representation. The statements weren't prepared by accountants without his knowledge. He reviewed them. He adjusted numbers upward. He signed them. The accountant's disclaimer, "We have not audited these statements," doesn't protect someone who knowingly submits false information. You can't lie to banks, then blame your accountants for not catching the lies. This penalty ranks among the largest corporate fraud judgments in New York history. Comparisons: ExxonMobil paid $476 million in 2020 for environmental fraud, though that was a federal case. Bank of America paid $1.27 billion in 2013 for mortgage fraud during the financial crisis. As a penalty against an individual executive for real estate fraud, this is unprecedented in scale. The precedent matters. Real estate valuation cases typically settle quietly. Developers and banks negotiate. Regulators fine companies. Individual executives rarely face personal penalties of this magnitude. Judge Engeron's ruling sends a message. Financial statement fraud has consequences. The penalties can be severe. The scrutiny can be intense. and wealth and fame don't insulate you from accountability. The ruling concludes with acknowledgement of the political climate. The court is mindful that this case has been the subject of significant public attention. However, the court's duty is to apply the law fairly and equally, regardless of the defendant's status or political position. By late morning, the ruling dominates every news outlet. Legal analysts dissect the decision. Political commentators debate implications for the 2024 election. And Trump's legal team promises immediate appeal, February 26, 2024, 10 days after the verdict. Trump files a notice of appeal. New York appellate rules create an immediate problem. To appeal, the appellant must post a bond for the full judgment amount. The purpose: ensure the money is available if the appeal fails. $464 million. Trump's lawyers claim it's impossible to secure a bond that large. Insurance companies that issue appeal bonds want collateral, liquid assets, or property pledges. Trump's assets are largely real estate, not easily converted to bond collateral. The legal filings argue that forcing Trump to post the full bond would require selling properties under distressed conditions, essentially liquidating assets to secure the right to appeal. March 25, 2024. The Appellate Division rules. They reduce the bond requirement to $175 million. Trump has 10 days to post it. April 2nd. Trump posts the bond through Knight Specialty Insurance Company. The appeal proceeds. The appeal arguments are predictable. Judge bias. The social media attacks on the judge supposedly prove he was predetermined against Trump. Attorney General political motivation. Letitia James campaigned on investigating Trump, which the defense argues taints the prosecution. No harm proven. Banks made money. The central victim claim remains. Excessive penalty. $354 million doesn't fit the crime when nobody lost money. Legal experts analyzing the appeal give Trump low odds. Overturning the liability finding that fraud occurred is extremely unlikely. The evidence was overwhelming. The judge's legal reasoning is sound. Reducing the penalty? Possible, but difficult. Appellate courts give trial judges deference on penalty calculations. The penalties here, while severe, are within the judge's discretion under the statute. Expected timeline: 12 to 18 months for the appellate court to rule. The verdict drops during the 2024 presidential campaign. Super Tuesday is 2 weeks away. Trump is leading the Republican primary field decisively. Trump's narrative is immediate and well-practiced. Election interference. The case is timed to damage his campaign. It's part of a coordinated effort with federal prosecutions. The classified documents case in Florida, the January 6th case in federal court, the Georgia election interference case. A fundraising email goes out within hours of the verdict. They want to destroy me because I'm fighting for you. The political impact is paradoxical. Polling shows Republican primary voters view the verdict as politically motivated. CBS News YouGov polling in late February 2024. 73% of likely Republican voters believe the case is a witch hunt. General electorate polling is more divided. Roughly 52% believe fraud occurred. The split predictably follows partisan lines. The effect on Trump's primary campaign, minimal. If anything, the verdict strengthens him with the Republican base. It confirms the narrative that the establishment, legal system, media, political opponents is targeting him unfairly. Trump wins the Republican nomination easily. The broader legal picture complicates everything. This civil fraud judgment is one case among several. 4 criminal cases pending as of February 2024. Georgia state prosecution for election interference. Federal January 6th prosecution. Federal classified documents, case in Florida. Manhattan District Attorney's hush money case. Trump is the first former president with a civil fraud judgment. The first to run for president while facing multiple indictments. The historical precedent is non-existent. The legal and political questions intertwine in ways that defy clean analysis. The cultural divide the verdict exposes is profound. To Trump supporters, this is proof the system targets outsiders who threaten entrenched power. To critics, it's long overdue accountability for decades of fraud. There is no middle ground. The verdict reinforces existing beliefs rather than changing minds. The business consequences are immediate and tangible. Barbara Jones, the independent monitor, reviews all major Trump organization transactions. Asset sales, new loans, significant contracts, all require court oversight. Banking relationships face strain. Some lenders quietly distance themselves. Deutsche Bank, already battered by controversy over its Trump loans, continues reducing exposure. Insurance carriers reassess policies. Coverage premiums likely increase. Some insurers may decline renewal. The 3-year ban creates operational chaos. Trump cannot run companies in New York. Eric and Donald Jr. face 2-year bans. The Trump Organization needs outside management for New York operations. Eric Danziger, a hotel executive, takes on expanded responsibilities. But the leadership structure fractures. Decision-making slows under monitor oversight. Asset liquidation questions arise immediately. Will Trump sell properties to pay the judgment? 40 Wall Street alone, even at conservative valuations, could cover much of the penalty. Golf courses, smaller properties, licensing deals, the empire has pieces that could be sold. But selling assets proves the financial pressure is real. It undermines the no harm narrative. It shows the judgment has teeth. Trump fights to avoid liquidation. The appeal bond at $175 million is manageable without selling core assets. But if the appeal fails and the full $464 million comes due, decisions become harder. The brand impact ripples globally. International licensing deals face scrutiny. Partners in Dubai, Indonesia, Scotland reconsider associations. The Trump name, once synonymous with luxury and success, becomes controversial. In some markets, it's a liability. Among MAGA supporters, it's more powerful than ever. The duality defines the post-verdict reality. Trump is simultaneously weaker and stronger, legally constrained but politically empowered. Beyond Trump's personal situation, there are victims most people never see. Consider a small real estate development firm in 2012. They apply to Deutsche Bank for a $40 million loan to develop affordable housing in the Bronx. The loan is denied. Deutsche Bank has hit internal lending limits. That same week, Trump receives $170 million from Deutsche Bank to purchase the Doral Golf Resort in Florida. The math is simple. Trump's inflated net worth, his fraudulent financial statements, helped him secure loans. Those loans consumed capital that could have gone to legitimate businesses. The honest developer lost their opportunity. The affordable housing project never happened. The market distorted by fraud. Every fraudulent loan is capital denied to someone playing by the rules. Insurance premiums work similarly. When Trump saved money through understated values for insurance purposes while simultaneously inflating values for loans, honest policyholders subsidized the difference. Insurance pools spread risk. Fraud by one party increases costs for everyone. Market integrity is an abstraction until you consider the concrete. Competitors who lost deals, borrowers denied capital, policyholders paying higher premiums. An anonymous quote from a competitor appears in court filings. We played by the rules and lost deals to someone who didn't. The public trust cost may be the deepest. Financial systems require honest dealing. When people believe the wealthy avoid consequences, cynicism grows. When rules appear to apply selectively based on wealth or fame or political power, civic faith erodes. This case posed a fundamental question. Does the law apply equally? Judge Engeron's 92-page ruling said yes, the law applies. Fraud has consequences. Wealth and fame don't create immunity. But the political reaction, the polling showing partisan divides, the fundraising surge, the narrative of persecution, suggests many Americans don't trust that answer. The civics lesson remains unfinished. The appeal continues. Criminal cases proceed. The 2024 election will render its own verdict. But the legal record is clear. Fraud occurred. The court found intentional, egregious, persistent deception. The penalties stand unless overturned on appeal. What remains uncertain is what, if anything, changes. Will this deter similar fraud in the real estate industry? Too soon to know. Some developers are reviewing valuation practices. Others dismiss the case as political persecution unlikely to affect them. Will reforms follow? Industry lobbyists resist increased regulation. They argue the market self-corrects, that sophisticated lenders don't need government protection. What does it mean for democracy when legal and political realities diverge so completely? When courts rule one way and voters believe another? The accountability paradox defines the moment. Legally, Trump was held responsible. A judge examined evidence and found fraud. Penalties were imposed. The system by its own measure worked. Politically, the verdict strengthened Trump with his base. Fundraising surged. Polling improved. The narrative of persecution resonated with millions of Americans who see the legal system as weaponized against their champion. Culturally, the nation divided further. The verdict became another data point in separate realities. To one audience, justice served. To another, justice denied. The system worked and broke simultaneously. Trump built his empire on perception. The brand mattered more than the buildings. The image of wealth created actual wealth. Perception became reality. Courts deal in a different kind of reality: evidence, documents, mathematical facts. You can't perceive away the square footage of an apartment or the deed restrictions on a property. The gap between those two realities measured $464 million. He wrote the book on the art of the deal. History will write the book on the cost of the fraud. But the final chapter remains unwritten. Appeals will take years. The political consequences unfold in real time. The business empire adapts under oversight. And somewhere in between the court's judgment and the electorate's judgment lies the deeper question this case exposes but cannot answer. When the brand becomes bigger than the truth, when the lie proves more profitable than honesty, when perception matters more than reality, where does accountability come from? The courts provided one answer on February 16, 2024. November 2024 may provide another, and somewhere between those two verdicts lies the real cost. Not just of this fraud, but of the world that made it possible. A world where financial statements become fiction, where valuations detach from reality, where the art of the deal becomes indistinguishable from the art of deception. The numbers didn't add up. Someone finally checked the math. The court ruled. But the deeper accounting, the cultural, political, and civic cost of a system where fraud can flourish for decades before facing consequences, that ledger remains open. History will calculate the final total.